All right, good morning. Good morning, good morning, good morning. So we are almost done. It's sort of hard to believe, but we're almost done. We have class today, class on Monday, then class on Wednesday, and that's it. So we're in the home stretch. Hopefully you are up to date with your notes and up to date with your readings. If you aren't, thoughts and prayers. It's hard to catch up in this class. There's a lot to remember. And I'm with you. So again, class today we're doing Griswold and Rowe. Class on Monday we're going to be doing some more recent cases of gay rights, and then last class this semester we'll do the Dobbs decision. So that will take us the entire scope of American constitutional law in one semester. Today, if you're interested, Professor Nelson and I are doing a debate at 4 o'clock. Is there a constitutional crisis? We both agree there is one. We don't agree which branch is causing the crisis, though. Stay tuned. It'll be fun.
Y'all should go.
Thank you.
It's not Pet Talk, but it's RLS. Y'all should still go.
It'll be fun.
That's it.
I think they're having Olive Garden catering. Is there not a note on the board? Oh, that's a fail. They're having Olive Garden, so it's good. So let's recap our due process cases. And we talk about different sort of phases, right? With regard to presumption of constitutionality. So let's see. I'll call on anyone. Just raise your hand if you know it. During the Lochner era, how did the court approach due process cases? Yes. With the presumption of liberty, who bore the burden? Government. Okay, good. We move forward towards the early New Deal cases, like Nebbia, like the insurance case. What standard review had the courts review legislation in that period? A presumption of constitutionality. That was rebuttable, exactly. What does that mean?
Government doesn't have to plaintiff does, but if they prove their case, the law is being done.
Very good. Which opinion from Lochner does that presumption of constitutionality match up with? Very good. Excellent. Very good. Then we get to our favorite footnote and Caroline Products in footnote 4. What happened there to the presumption of constitutionality? It qualified. How so?
Like if it's listed in the Bill of Rights, then it's not.
Good. Good. Caroline Products qualify the presumption of constitutionality with these 3 carve-outs. All right, 3 carve-outs. First, if there's some right in the Bill of Rights, we can use more demanding scrutiny. If there's some law that might impact the political process, however defined, the courts will review it more closely. And if there's a law that impacts what they call the discrete and minorities, however defined, more heightened review. Then we get to the 4th and sort of final phase from due process story, till today at least. And what's that 4th and final phase? Who knows? But yeah, William C. Lee Optical. What did Lee Optical say? It can't be rebutted. If the government has even a conceivable basis, some rationale they can even make up, that's enough to pass scrutiny. All right, so that takes you from 1905 with Lochner till 1955 with Lee Optical. And if you went to law school in 1955, that would all make a heck of a lot of sense. But you didn't. Right? Your parents were probably even born in 1955. Right? In the decade between 1955 Lee Optical and 1965 Griswold, a lot happened. As they say, if you remember the 60s, you weren't there. True enough. There was a civil rights movement that was burgeoning. There was the counterculture movement, women's rights movements. All these sort of movements sort of coalesced in this very contentious period. And this sort of thinking spilled over into the courts. Also around this time, the Supreme Court began toying with this idea of a right of privacy. It really began in cases involving criminal procedure, right? Searches and seizures. So for example, if the government searches your home, but they find pornography, well, maybe a First Amendment right to keep that stuff, right? The court began toying with the idea of a right of privacy, but they were still operating within the settlement from Caroline Products and Lee Optical, right? These were almost all New Deal justices. They came of age when Lochner was evil. And they could never go back. By the way, Oscar, did you see how much about Lochner today in the readings? They're obsessed. They cannot get past it. They're haunted by Oliver Wendell Holmes's ghost for the rest of their lives. They can't. Like John Roberts has nightmares about Holmes, right? But by the way, in a Burgerfell, the gay marriage case, Roberts cites Holmes and Lochner. They cannot get away from this case. A case about baking bakeries in 1905 is like the most important case ever. It still boggles my mind all these years later. So we have now Griswold. And the justices have this sort of dilemma. There are clearly the votes here to rule in favor of Griswold and Planned Parenthood, right? The votes are clearly there. But the question is how they do it. They just decided Lee Optical 10 years earlier. In fact, Justice Douglas wrote Lee Optical. The same guy who wrote Lee Optical wrote Griswold. Think about that for a minute. Lee Optical says we must defer. If there's any basis whatsoever for the government to prevail, that's good enough for us. And then we get to Griswold saying, no, this law has been around for 100-something years, it's unconstitutional. So what's the challenge for the court? How do they find a right to contraception without overruling or even revisiting Lee Optical? How do they keep, the question up here, how do they keep a right of contraception consistent with Caroline Products? They did it through the Bill of Rights. Caroline Products said if there's some right in the Bill of Rights, we give it more demanding scrutiny. And so the court has this idea of, well, there are these rights in the Bill of Rights, right? There's the First Amendment, the Third Amendment, the Fourth Amendment, but we don't read them so literally, right? They have these emanations, these numbers. I'll get to that later, right? That the actual provisions of the Bill of Rights speak to other things, and that's how they did it. The reason why this opinion makes little sense to students today is they forget what common law was like in the 50s and 60s. At least Brown fit within the discreteness minority part, footnote 4, right? But what do you do about birth control? They stuck it in with the Bill of Rights. All right, Stephen?
In Griswold v. Connecticut, is this the warrant court that's doing this?
Oh, it is?
Was Caroline Products not the one court?
No. That was the Stone Court. But many of the justices, right? Hugo Black was there, William O. Douglas were there. A lot of the former New Dealers are still in the court by the time you get to the 1960s. All right. So let's do this. Let's do the facts. Oh, before I do the facts. Okay, let's do the facts in Griswold. Okay, who am I up to? Who's up? You. You know what? Yeah, you don't shoot the messenger. Okay. Give me the facts, please, in Griswold.
There's a state law that had criminalized the use of contraception by married couples.
Why is that? Let me just pause for a second. Why did the law only apply to married couples? Only married people have that act? Well, you're not wrong. So this is the part of the case people don't quite appreciate. It was a crime to have sex when you weren't married. There was a separate crime for that, right? They didn't need to ban birth control for non-marital sex, so the act itself was illegal. It was illegal. Fornication, adultery was a crime. It was literally a crime. This is why Loving versus Virginia, right? Why was it so important they got married? it would have been illegal for them to have relations if they weren't married. So the law itself only applied to married couples. Now, I'll ask Bobby the question. Why would the government ban birth control for married couples?
Kind of like the idea of like why we think family is so important, because you're like propagating the species.
Yeah. So in Meyer against Nebraska, why they think that marriage was essential to the survival of the species? Reproduction, right? If couples aren't reproducing, we will die off. This has been understood for a very long time. That's preview next week. The reason why marriage exists is to encourage reproduction. It wasn't about love. It wasn't about happiness. It wasn't about fancy weddings and diamond rings. That wasn't it. It was like kids. Right? That's why marriage existed. It's a lesson that doesn't resonate well today, perhaps, but that was a reason. So Connecticut said, we want to make sure that married couples are together and they're intimate. They will have offspring and they cannot use these devices. Now, the law made it twofold: a crime to use it, but also a crime to counsel people on using it. So doctors cannot prescribe it. Planned Parenthood couldn't give information about it, brochures and the like. So the plaintiff in this case wasn't a woman saying, "Oh, I want to use birth control," right? Conrad, how did this case arise?
With physicians being fined and then not paying the fine.
Yes. So Planned Parenthood opened a clinic in New Haven, Connecticut. If you don't know, that's where Yale Law School is, right? It's like the center of the sort of their legal counterculture movement. And they were very deliberate in bringing a test case. Now, this is not widely known, but at the time, Connecticut barely enforced this law. Even by 65, people were like, well, we have this law in the books. Maybe we shouldn't be snooping people during the bedroom. In fact, the Connecticut legislature was poised to repeal this law. If my memory serves, I think either the Senate or the House, one of the houses actually passed a repeal bill. It was headed to the other house. So had the Supreme Court not ruled, this law would have been repealed and disappeared to the ashes of time. This is sort of like the Equal Rights Amendment we talked about last week with the Frontiero case, right? Had the court not ruled in Frontiero that we are now applying this heightened scrutiny for sex discrimination, maybe we'll pass an amendment to the Constitution. When the court gets ahead of legislative process, the people's like, okay, we don't have to decide for ourselves. We'll let the judges do it for us. So this law was rarely repealed. If you actually look in the video, there's a photograph, or in the textbook, there's a photograph of Estelle Griswold and Dr. Buxton getting arrested. Is it usually the case when people get arrested that the press is there with cameras? No, it was a setup, right? They wanted to get arrested. It was a complete setup. They were imposed, I think, a fine of about $100, which, was not nothing, but it was at least something they can take and appeal up. And the case goes to the Supreme Court. And the justices have to deal with it. All right. So if we were sort of just being, neutral here, right? Imagine you were a law student in 1965. I give you all the cases decided, right? You read Lee Optical, and you get this case by birth control. You think to yourself, oh, this is easy, right? The state can promote morality, right? The state can promote interest in having more children. Is that a reasonable state end? Sure. Is it conceivable that making couples use birth control will result in more children being born? Yeah, you better write it. That's not conceivable. That's likely. Okay. Law is constitutional. Done. But that isn't what happens here. Not even close. So the first part of the case I want to talk about is what I've often called Lochner-phobia, right? You have like arachnophobia, agoraphobia, fear of open spaces. Supreme Court lawyers have this fear of Lochner. Like I can't explain. It's irrational. I don't know, Martin, what you think? People just afraid of Lochner. I don't think it's that bad, but maybe I'm an outlier. But Justice Douglas has an entire section of his opinion saying, we're not doing Lochner. This is not what we're doing. Please, Justice Holmes, don't haunt me, right? This is not Lochner. And then you got Justice Hugo Black in dissent. And Hugo Black was like, Lochner. What's funny is Hugo Black didn't even know what Lochner was. If you listen to the oral arguments, wasn't Lochner the case about the weight of a loaf of bread? He forgot what the case was even about. That was actually another case called J. Burns Bakery. This was a case where the government regulated how much bread had to weigh. And that was a way to punish small bakeries that couldn't make very precise loaves. Anyway, it's another case, not important. But Justice Douglas puts in his opinion, he says, some people might suggest that Lochner's the guide here, but we decline. What case does Justice Douglas cite? West Coast Hotel versus Parish, the minimum wage case from 1937. He's saying, and look, he was a New Dealer. He was there in 37. He knew what this was about. He's saying, look, we're not revisiting Lochner, right? We overruled Lochner, 20 something, 30 something years ago, right? We're not doing this anymore. So how does he distinguish Lochner? Teddy, how does Justice Douglas, and he does it very, very subtle. How does Justice Douglas purport to distinguish Lochner from the birth control case?
He talks about the protected activities and the intimacy that is involved in something like conscious, I guess, having children, man and wife.
You're actually answering the question. You're giving me the analysis, but how does he distinguish a regulation on hours that bakers can work from a regulation what couples can do with birth control? He has a distinction. What's the distinction of each of us? It's a very important distinction.
He talks about the penumbra.
We're not there yet. We'll get to the penumbras in a minute. I promise. We'll get to the penumbras. I promise.
I guess I'm not quite sure.
Chanel?
What you're asking.
What kind of right was at issue in Lochner, Chanel? How would he characterize it? Remember I drew this distinction when I talked about Meyer and Pierce versus Lochner. What's this is? Teddy, you got it?
Individual right?
No. I want one person time. Yeah, one. Yes. What was Lochner about? You said before.
Economic and then commercial,
And what's the birth control case about?
individual.
Personal. Good. So if you remember when I talk about Meyer and Pierce, right? When I talk about Meyer and Pierce, Meyer was about teaching a foreign language, right? Pierce was about sending your kids to school. We describe these as mostly as about personal liberty. That is the parents' role in the upbringing of their child, right? They can direct the upbringing of their child. These are personal cases. Buck v. Bell, right? The sterilization case, personal rights. By contrast, Lochner, Atkins, West Coast Hotel is about hours and wages and labor. These were economic, commercial cases. Until you get to Caroline Products, this distinction doesn't really exist, but Caroline Products kind of hints at it. Then maybe economic rights are different, but Griswold makes it clear. Griswold says, we will not sit as a super legislature to review economic problems. That's what he says. We will not sit as a legislature to review economic problems. Basically says, whatever Caroline Product said, whatever West Coast Hotel said, that was an economic laws only. Those cases were not about personal, individual rights. This law touches on an intimate relation of the husband and the wife and their physician's role, which is kind of weird, right? It's not just the woman's right, it's the doctor's right. Don't forget that one, right? And it touches on this intimate relationship. This is how the court breaks free from Lochner. Not very convincingly, perhaps, but they say, we are going to say if it's a right of individual liberty touching the body, we'll give heightened scrutiny. But if it's the body working in a job, economic, that goes back to the optical and deferential scrutiny. Everyone see the distinction that they drew. Everyone see this distinction that they drew. By the way, even if this is a right that's intimate to the husband and wife, the doctors are a regulated profession, right? Doctors prescribe lots of medicine that's regulated. So that's not very intimate, right? The intimacy might be in the bedroom, it's not in the doctor's office. At least it usually isn't. Shouldn't be, at least. If it is, it's a problem. Okay. Hello. Hi. Okay. So then the court begins to reconcile the precedents. And I told you about this weeks ago. They basically say that Meyer and Pierce, these cases about parental rights, were in fact First Amendment cases about religion. They weren't, right? That wasn't what those cases about. They were due process cases. But to avoid this incongruity in the cases, they sort of move everything around. Buck v. Bell is not mentioned anywhere. And just hold it for a second, right? The government can literally sterilize women who would have a right to birth control. Think about that one for a minute, right? Just line those up. They don't line up. It won't work. All right. And because there's First Amendment implications for Meyer and Pierce now, that goes to the first paragraph of footnote 4, Bill of Rights. So everybody get why the court did what they did. Right? Everyone get why the court did what they did. Michael?
And just to make sure I'm getting it, it's because if they didn't like reframe like Meyer and all those, then they would kind of be deviating from that structure.
Yeah, because we give only, let me put it this way. Meyer and Pierce drew no distinction between economic rights and personal rights. Meyer applied Lochner. Meyer applied Muller, right? It was the same standard. So what they have to do is basically separate Meyer and Pierce from the Lochner cases. And they create this economic distinction. And in fairness, and I actually spent some time looking into this, almost every case after Caroline Products was involving economic rights. I couldn't find a single, maybe Martin, I couldn't find a single purely personal liberty case between Caroline Products and Griswold. I couldn't find it. I actually asked around, no one could find it. Stephen, do you know what it is?
Well, I was about to say, Pierce and Myers was economic as well as personal.
They were actually both. Yeah, to prove the point, they blended. They weren't actually separate. Those cases disprove Griswold, right? If you actually read Meyer and Pierce, it negates everything that Justice Douglas wrote. But my question was a little bit different. After the court decided Caroline Products, I can't find a single Supreme Court decision, as a majority decision, that focuses on a personal liberty case, right? The court just didn't take any. I don't know. So they had to go all the way back to Meyer and Pierce to sort of figure this out. Okay, follow with me so far. All right. Anyone ever take astronomy? Yeah, I like that class. Anyone ever see the eclipse? Did you guys see the eclipse last year? No, not in Houston, in Dallas. The actual eclipse, the full eclipse, the totality. I did. I was in Dallas, yeah. And I went before that to San Antonio a couple of years before that. And I actually went, oh my gosh, it's terrible. This is in 2016 or 17. I went to Nebraska because there was a total eclipse there. I flew all the way to Beatrice, Nebraska. You can Google it, it's a real place. It was cloudy. I didn't see a damn thing. I was so mad. And then there was so much traffic because there was one lane highway was not meant for all those people. I almost missed my flight. My class next day. Anyway, but let's talk about astronomy just for a moment, if you can. What did you say? Well, the eclipse was here last year, but in Houston, it's only a partial totality. You get the full totality. The full totality is pretty cool. You can't describe it. All right. So I put this in the video because I can never do this right. So I'll just put it. Okay.
He wrote, quote, specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Astronomy guide. An emanation refers to a ray of light. During a lunar eclipse, the umbra refers to the darkest part of the shadow formed when the Earth orbits between the sun and the moon. The penumbra refers to the lighter part of the shadow, where some of the emanations from the sun are visible. If you don't understand this analysis, you're not alone.
I wrote that line. I wrote all the lines, but he delivered it well. It's funny, Randy's class, whenever there's a typo, he blames me for it. He tells me, yeah, that typo's Blackman's fault. So I'll take the good parts. So what the hell is Griswold talking about here? So how does astronomy work, right? This is not to scale, but you get the idea. The sun creates light, right? What is a lunar eclipse? A lunar eclipse is when the Earth is exactly in the path of the sun's light. And when you block light, what do? You create a shadow. There are two types of shadows. The umbra, not umbrella, the umbra is the darkest part of the shadow where no light permeates. This would be actually a partial solar eclipse. The penumbra is the lighter part of the shadow where some of the light from the sun permeates. This would be a partial eclipse. So these are the umbras, these are penumbras. These are the emanations. The emanation, I can't believe I'm doing this. The emanations come, I hate this thing so much, right? The emanations come from the sun and they cast light. So Griswold says, the specific guarantees of the Bill of Rights, the first, the third, the fourth, the fifth, the ninth, not the second, does not mention that one, Lord help him. The first, the third, the fourth, the fifth, and the ninth. Why the hell not? These have penumbras formed by emanations that give them light and substance. In other words, you have the text of those rights, but then you have stuff around these rights, these penumbral rights, kind of like Indiana Jones, like lights shooting out the document, right? And these various guarantees create zones of privacy, right? 1 second. Like the First Amendment's right of association, which is not really in the Constitution, it's assembly. The Third Amendment, you can't quarter troops. The Fourth Amendment, secure against searches and seizures. Fifth Amendment, you can't incriminate yourself. All this means that there's a right of privacy in the Constitution. Got it? I don't. Yeah, Oscar.
So are you saying that the numbers only apply to the first or third, fourth?
I don't take this literally. It's not meant to be taken literally.
Okay, yeah.
It was the 60s. It was a wild time. No, I don't mean to be glib, but the harder you think about this, the worse, the more painful it is, right? This is not meant, even people who favor broad reproductive rights don't buy this opinion, right? You want to look at the opinion that matters, go to Justice Harlan's opinion, right? Or maybe Justice Goldberg. We'll talk about that in a few minutes. But the majority opinion by Justice Douglas is, even on people on the left, is viewed almost as a joke, right? But why is he doing this? Why is he engaging in these gymnastics of penumbras? Why doesn't he just say, like Justice Harlan does, that the Due Process Clause protects liberty, and liberty includes the right of privacy? Why can't he just say that, Oscar? Why can't he just say the Due Process Clause protects liberty and let's be done with it? What's he afraid of? Lochner. It's all about Lochner. He has footnote 4 to deal with. He cannot get away from footnote 4, that darned footnote. So between filled milk and baked goods, we're stuck in common law, right? We are trapped by a baker and a guy making condensed milk. That's our state of American constitutional law. Something, isn't it? I wasn't exaggerating. I said it's an important case. So they go through all these gymnastics about the First Amendment, the Third Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment. We'll get to the Ninth Amendment later, Goldberg. All talking about what? To stay away from substantive due process. That's all it is. So you're asking me, like, which amendment makes the penumbra? I don't know. You know, how many angels dance ahead of a pin? I don't know. Right? It's not meant to be taken seriously. Okay. Not even Roe, by the way, actually like agrees with this penumbra stuff. By the way, when you get to Roe, only 8 years later, like, yeah, we're not gonna do this penumbra. We'll go back to the 14th Amendment. Like they just got over their Lochner-phobia, right? They got over it. But Douglas is still sort of cursed by Lochner. All right, with me. So then how do you do this case? Right? In this case, you have a relationship lying within the zone of privacy. And just to be clear, the relationship is not just husband and wife. Because who are the defendants here? The doctor. It's relation between the husband, wife, and the doctor. I'm not sure why the husband's involved in that relationship, but in general, right? It's the troika, the trinity, right? That they can make it. By the way, when you get to the abortion case, husband's out of the picture. In fact, the Supreme Court said husband has no role in deciding whether to have an abortion. They got that. They got rid of that one, right? So this is actually short term. There was a case from 1970 or 72 called Eisenstadt v. Baird, Baird, where the court said, yeah, we said in Griswold this right of privacy is for the husband and wife. We didn't mean that. Unmarried couples can have this right too. So this didn't even last like 5 years, right? All the the husband and wife, they got rid of that. It's like, oh, well, unmarried couples, yeah, you can have birth control too. So none of this really matters, right? It didn't even survive like 5 years in the Supreme Court, 6 years maybe. It didn't matter. So, but we'll still teach them. Okay. Now the court makes a point that's actually fair, right? How would this law actually be enforced? How would you actually know if a couple is using birth control? Would we send, inspectors to the bedroom to check their nightside table, right? To check what they're doing during their relations? Are we really going to do this? You might think about Bowers against Hardwick. Are we sending police to see people engaging in sex? Well, apparently, right? Lawrence v. Texas, apparently. But the lawyer who actually was Lawrence's lawyer, he's alum of this law school. You'll see him around from time to time. But it's only a very unusual circumstance we actually see people sort of in the act, if it were. But they can criminalize the prescribing of these drugs, right? That's in a medical office. Regulations are afoot. So the stuff with the husband and wife is all good, but the actual regulating the people dispense it, that's actually not hard to enforce at all. Then we get to the sanctity of marriage, right? The sanctity of marriage. This is William O. Douglas. William O. Douglas, sanctity of marriage. He say, we deal with a right that's old in the Bill of Rights. Marriage is a coming together for better or worse, hopefully enduring. Stress and hopefully for him. And intimate to the degree of being sacred. So William O. Douglas was divorced 3 times. His wives got progressively younger as they got older, and he had a habit of marrying secretaries. I think actually his final wife is still alive. I think she's actually still alive because she was quite young when they got married. So Douglas was actually considered to run for president or vice president, and he couldn't because he was divorced several times. So for him to talk about all these marriage is some chutzpah, right? I mean, it's supposed to be in with this, like some gall, right? Some nerve for him to just preach about marriage when he was not a very faithful person himself. But whatever, it was the 60s, and everything flew back then. Okay. All right, with me. So again, the court limits this to be talking about marriage. But only a couple years later, they eliminate any distinction between married and unmarried couples. All right. Everyone, again, you get the majority opinion. It doesn't really matter if you do, but you understand at least what the footnote 4 stuff is. You got that? All right. There are several concurrences in Griswold, which frankly are a lot more useful to teach. The first one was by Justice Arthur Goldberg. He held the Jewish seat for some years, only briefly. The funny story about Justice Goldberg, he's only in the court for about 4 or 5 years. Why did he step down? It's genius. Lyndon Johnson, say it will, he was a political genius. He wanted to open up a seat in the court. He wanted to have an open seat in the courts. What did he do? He told Justice Goldberg, I need you. I want to make you the ambassador to the United Nations to fix the Vietnam War. Please step down to the Supreme Court and create a seat on the Supreme Court for me. And amazingly, Goldberg did it. He stepped down. And he went to the UN and it was an absolute waste of his time. And he regretted resigning from the Supreme Court. He was on the court for, I think, 3 years, actually. I just checked, 3 years. Who was replaced by? Abe Fortas, who was Crody. He was best friends with Johnson. Oh, and LBJ did it again. He went with Thurgood Marshall in the Supreme Court. How did he do it? So Justice Clark was on the court. Tom Clark. LBJ appointed Tom Clark's son as Attorney General, which would have made him recused in every single government case. So, you think Trump's savvy at the Supreme Court? Oh, hold my beer with Lyndon Johnson. So LBJ got 2 seats open up just by himself. Amazing. Amazing. Just you can hate the player, but don't hate the game. He had game. And he figured it out. But Justice Goldberg was on the court for a couple of years. And he has a thing about the Ninth Amendment. And where's my Constitution? It's my bag. Anyway. So the Ninth Amendment, right? I remember. It says the enumeration of certain rights shall not be construed to deny or disparage other rights retained by the people. That only does. Right? They get it? Yeah. Yeah. That's what I do. Right. I have my daughter, like, I love the Constitution shirt. Yes, we're so proud, like Chick-fil-A. I love the Constitution. So she was there yesterday. Sure thing. I love the Constitution. I went to school and then Chick-fil-A after. Yeah. Where else would you wear it? Anyway. Yes. Tuesdays is fast food Tuesday. That's what they call it. So after school, we go to Chick-fil-A. That's the thing. Fine. Okay. So the enumeration of certain rights shall not be construed to deny or disparage other rights retained by the people. I think I mentioned this maybe the first week of class, but the purpose of the Ninth Amendment was at a minimum to exclude the expressa unius canon. Okay, we list these rights, speech and religion and so on. Okay, that's it. Those are the only rights we have. We list nothing else, right? And the framers were worried, like, well, if we only list these rights, then people think that there are no other rights. So they put this amendment in. But that doesn't answer the question of what rights are retained by the people. Right? What are these rights retained by the people? So my colleague, Randy Barnett, is like, if not the number one, top 5 experts in the world in the Ninth Amendment. I won't even try to do justice to his work. But Randy believes that this concept of natural rights this concept of rights refers to natural rights, rights retained by the people even before government. You don't need to believe him. That's not important for right now. But the Ninth Amendment only really applies to the federal government, right? It was limitation of federal power, right? We're listing these rights and we're saying that you might have some other rights. That says nothing about the rights retained by the people. Which part of the 14th Amendment might protect unenumerated rights? Come on. Which clause? Privileges or immunities. But which case killed it? You got it. We're stuck by slaughterhouse. If you want to find a right of privacy in the Constitution, it's probably in the PRI clause, but we can't talk about slaughterhouse because, the butchers, right? Those butchers, we can't give them anything. Seriously, slaughterhouse and law can explain almost all of American constitutional law. Those 2 cases, it's sort of stunning. A case about butchers and a case about bakers. Right? Just so much stems from those 2 opinions. So you got it. But Justice Goldberg makes a point. He says, well, the Ninth Amendment teaches a lesson that those who framed the Constitution thought there were some rights not written down. Maybe that's the right of birth control. Maybe it's not. Now, would anyone in 1868 have thought there was a right to birth control under the Constitution? Of course not. Right? It's preposterous, right? And they don't make a historical argument. We'll get to that one in Dobbs next week. But he says, well, it's just kind of, it shows that maybe there's some rights and whatever. So people like the Goldberg opinion until they read it too carefully. Then there's not much that they go, okay. So then we have Justice Harlan, the second. And this is actually the grandson of Justice Harlan the first. Isn't that kind of cool? Your grandfather was in the Supreme Court. You're named after him. You go in the Supreme Court. That's kind of cool, right? Number 1 was a heck of a lot better than number 2, right? Number 1, we're still reading his dissents 100 years later. Number 2, you probably never heard of him. He was kind of the moderate of the time, kind of this kind of old school Republican appointee. I mean, I won't call him conservative, but he's in no sense conservative, but just kind of just more moderate, more restrained, more aristocratic. And Justice Harlan had sort of come to terms with Lochner. He had written an opinion about a year or two earlier called Poe v. Ullman. You might have seen it referenced, Ullman, where he basically said, you know what? Let's just get over this Lochner phobia and let's just recognize that the due process clause protects certain liberties, right? It protects rights that are not written down. It protects these values. Here's this phrase, implicit in the concept of ordered liberty. Did everyone see that? What the heck does that mean? Anna? What does that mean? Implicit in the concept of ordered liberty? I still don't know what it means, actually. You tell me, maybe figure it out. Implicit in the concept of ordered liberty.
Hey. I'm not sure, actually.
Martin, you know what it means? Yeah. He's teaching Colin, by the way, next fall, so welcome. I don't know what it means. I've been doing this for many years. I have no idea. I'll tell you what the court says it means, but I still don't really know what it means. What's ordered liberty, right? Our society, think, okay, we're free, but we can't do whatever we want, right? So there's structure to society. There's liberty in an orderly fashion, right? There's actually a line that Justice Brandeis wrote in a case called Palko, P-A-L-K-O was it versus Connecticut, 1923, maybe off by a year or two. So what are these rights that are so important to society? They're implicit, they're essential in our system of liberty. And if a right is so important, then the courts can recognize as a fundamental right that warrants heightened protection. The court introduced this test to discuss incorporation, right? What provisions of the Bill of Rights are so important that we need to extend them to the states? So what Harlan's saying is there's some rights that we need as society. Does society need birth control? No, that's not how he looks at it. He says society does need privacy for married couples. It's so essential that married couples have privacy that this right must be protected by the judiciary. That's what he's saying, that it's implicit, it's essential in our society, an ordered liberty society. Everyone kind of get that? If you don't, that's fine. I'm not gonna test you on what that means. I learned that when I was in college. Like, what the hell does that mean? Professor didn't explain it, so I'm at least giving you the benefit. Yeah, Oscar. It was substantive due process. What is it called that? Right. I mean, why does the provisions of the Bill of Rights apply to the states? They're considered liberty in the 14th Amendment, right? The incorporation doctrine is substantive due process. In fact, this is, Justice Scalia, for example, despite all of his hatred of substantive due process, said, well, I'll go along with this for incorporation. He wouldn't use the privileges or immunities clause for incorporation in the McDonald case for the Second Amendment. Only Justice Thomas would. Yeah. I mean, really, all of common law is like Slaughterhouse, Lochner, Caroline Products, Lee Optical, and Roe, like 5 or 6 cases defines the entire thing. Fit everything in like 5 cases. Get those cases, you know the story. All right. Everyone with me. Justice Byron White, I like to talk about him because he was a remarkable person. He was a human being extraordinaire. He went to Yale Law School. He was a Rhodes Scholar. He also was drafted to the NFL. He was a professional football player. He took time off from law school to go to the NFL. I mean, he was a remarkable person. He was huge. Like, he was so strong. They had a basketball court, Supreme Court, called the highest court in the land. And you had all these 20-something clerks try and challenge him to a game. He would just beat their butts every time. He was like in his 60s, it wouldn't matter. He was such a good athlete. And the story goes that one day he was playing a game while the court was in session. And because the basketball court is above the Supreme Court, you hear the dribbling, boom, 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 boom. So they put up a sign, no playing basketball in the courts in session. But he was a remarkable guy, just a life well lived. Interesting, he dissented in Roe, but he voted with majority in Griswold. I think he's the one who flipped like that. And he says nothing justifies the scope of the statute because it affects married persons. So there's something of how do you define a right? Is this just the right of birth control? Is it the right of a woman to use birth control? The right of a married couple to choose to use birth control? Or the sanctity of the marital privacy of the bedroom? Depending how you classify the right, it looks like a very different case. For example, with what do you call it? Bowers. Is it the right of homosexual sodomy? Well, that seems pretty narrow. Or is it the right of intimate association to love who you want to love? Right? Depending how you frame the issue, it comes out real differently. Right? The case looks a little different. All right. So there were two dissenting votes. I'm sorry, there were two dissents in Griswold. So you had Justice Hugo Black. Again, Hugo Black was a New Dealer. He was what you would call today a textualist. He's like, there's nothing in the Constitution that speaks for a right of birth control. And he goes, Lochner, Marshall, Lochner. Get the Marshall Brady bunch? Okay. Your references are dated, Martin, before you even start. Your references are already dead. I know, it's terrible. I got nothing. Besides Lochner, Meyer, and Pierce, we rejected these cases. Then you have Justice Potter Stewart, and he has a sort of a funny line, or maybe a famous line, where he says, "This law is uncommonly silly." He calls it a silly law. And I admit, over the years, I've sort of changed my mind on this one. What business is it of a judge to have a law silly or not? Why is that his business? Right? That's not his job. Legislature passed it. They thought it was important. They don't like it, they can repeal it. Because it's a silly law. It might be true. Now, Justice Thomas used the same line in Lawrence to speak of the Harris County or the Texas sodomy laws as uncommonly silly. And you should defend Thomas. I think he was wrong on that one. It's not his business if the law is silly. Thomas said, if I were in the legislature, I'd repeal the law. Well, if you want that, you can resign and step down and go get a job in another branch, but you're not, right? Anyway. But Justice Stewart says that this is in no way protected by the Constitution. Okay. Curiously, Stewart dissented in Griswold, but he joined the majority in Roe. So he flipped also. So White was in the majority in Griswold and dissented in Roe. And Stewart was in the dissent in Griswold, but majority in Roe. Stewart later said, all right, you know what, substantive process, I submit, you win. He gave in. So they switched places, Potter Stewart and Byron White. Okay. All right. Questions on Griswold. Not Clark. Estelle. No, Clark Griswold is, please. Thank you. Yes, Bobby.
Did this overrule Buckley Bell?
Not even close. No. No, in fact, Roe reaffirms Buck v. Bell, cites it favorably. Yes.
So, to me, this case basically, like, the main point of this case is basically just to protect, like, the sanctity of, like, married people.
Yes, but they abandoned this case almost immediately. In Eisenstadt v. Baird, Baird, this was a guy, I think he was in Boston, who was distributing birth control to was it Boston University or Boston College? I can't remember. He was basically having a presentation for a bunch of college students, and he was distributing, I think it was foam, some sort of a contraceptive foam, if memory. Someone Google me on that one. Some sort of vaginal foam, whatever. Sorry, my memory is replaying in real time. And he was arrested by the police for basically distributing this contraceptive to female students. And the court said, well, it violates equal protection to give a right to married couples, not unmarried couples. You're treating them unequally. So all this doesn't matter, right? Not even 5 or 6 years later, they abandoned the entire marital sanctity, right? Because unmarried couples had it as well. It's a curious thing. Could the government actually ban adultery? In Griswold, they said, yes, you can ban adultery, you can ban bigamy, you can ban fornication, marriage outside of sex outside of marriage. And they banned all that a couple years later. So this was just kind of a way station. Yeah, Oscar. I wouldn't cite that in a court of law today. I think you'd have a hard time making that argument. If in the seventies, I'd give you a different answer, but I think today that would not get you very far.
It's more like hippie culture was like a big deal with like their like.
Hippie culture, what's hippie culture? What's this hippie culture you speak of?
I mean, you know what I mean, like.
I know, you know what I mean.
The, stuff like that.
Woodstock and stuff.
But I
Yeah.
guess it was something much bigger from like this perspective. I don't know, I guess we've always seen
Did
that
you
as
do a case, did you do property too yet?
Yeah.
Have you done the case of Village of Belterra versus Boris, a zoning case? Well, no, well, also after you go Village of Belterra versus Boris, this was actually a hippie case. The town of where Stony Brook University is in New York, there's a small hamlet, small town, and they basically banned unrelated people from living together. They want to ban communes, hippie communes, and the Supreme Court said it was unconstitutional. There was another case. Oh, was it USDA versus Moreno? Moreno case from Brendan Pinion from the 70s, and basically it was a limitation on food stamps for hippies. And if you actually listen to their argument, they're talking about the hippies. They're basically not working and getting food stamps. And this is a case the court said we can't have moral disapproval of people. In other words, we can't just deny them benefits because we don't like hippies, because we disapprove of their morality. Supreme Court said you can't do that. So that would not be the law today. There were a number of cases involving hippies. You have the draft cases, right? You know, fuck the draft, burn your draft card. These are all counterculture cases that are around the same time, right? Where the court basically said these people are contrary to our what does counterculture mean? You're counter to the current culture. We're still going to find protections under the Constitution. The court embraced. I mean, it's often said the Supreme Court's never too far from the headlines, right? And the court in the 60s and 70s was not too far from the counterculture movement. I mean, they basically, during the Watergate period, they kind of just followed the headlines. I mean, problem today is the Supreme Court follows headlines too, but only certain newspapers. Not the ones I read, maybe, I don't know. Yeah, Barbie.
Goldberg uses, what looks like strict scrutiny, but he says it needs to be compelling,
He does say that, doesn't he?
and he says it's not tailored enough.
Yeah.
So is that, can you use those words?
Well, it's a concurrence, so you can't really make that the majority. The better question with Roe, we'll get to in a few minutes, is did Roe apply strict scrutiny? People debated that question for almost half a century. Now it doesn't matter, but I think Roe is probably something close to strict scrutiny. Right. Any other questions in Griswold? Yeah, it's a weird case. Not what you think. I don't like teaching it. What's I supposed to do with this penumbra? It's like astronomy. I don't know. All right, Roe. So this is a case that almost needs no introduction, but actually does, because people don't know what the facts are at all. So Norma McCorvey was actually a Texan. She lived in, did you ever meet her, Martin? Yeah. She lived in, I think she was in Sugar Land her last few years in life, so she actually was here. I always wanted to reach out to her, but I didn't. She had a tragic life, and I frankly didn't want to bother her. She was a young woman in Texas. She had 2 prior children, which she both came up for adoption. And she got pregnant a 3rd time. And she wanted to obtain an abortion. I think she was living I think she was in Dallas at the time. So her friends told her that if she said she was raped, she'd be able to get an abortion. It actually wasn't true. Under the law, there was no exception for rape, so the story didn't matter. But she basically fabricated a rape allegation that was untrue. So she accused people of rape or accused an unknown assailant of rape, but it wasn't true. The relationship was consensual. So then she attempted to get an illegal abortion, but she couldn't find one. So then she sought out 2 lawyers, Linda Coffey and Sarah Weddington. Sarah Weddington then became a professor at UT. Do you know Sarah? Yeah, she's at UT, right? Yeah. So I'll speak somewhat ill of her just slightly. No, this is important. At the time, Weddington was looking for a test case to challenge the Texas abortion statute. So who's the plaintiff that you need to challenge the law? you need a woman who's pregnant. And you need her to stay pregnant. Because the woman's no longer pregnant, then she loses her injury, her standing. So again, this is, depending how you look at it, a sad or happy or sad case. McCorvey just wanted an abortion. She didn't want to be a member of this thing. It's pretty clear to me that Weddington maybe wasn't fully honest with her client. And she probably could have gotten her the abortion. But instead, she didn't provide her a recommendation to keep her having standing. Years later, McCorvey would say that she was lied to by Weddington and others. And, well, Weddington made, okay, she was a law professor, so, yeah. The reward was there. One curious quirk, though, a pregnancy lasts approximately 9 months. A Supreme Court case takes several years. Why does the court keep the case even after McCorvey gave birth? This is a doctrine called standing, right? How do you have a standing? Ready for this? Capable of repetition, yet evading review. Capable of repetition, yet evading review. In other words, if there's some problem that keeps popping up, but can't be resolved quickly enough to be resolved by the courts within, 9 months, the court can keep the case. It's one of these weird abortion rules they wrote into federal law that doesn't make sense almost anywhere else, but almost every case. Later case would not be brought by the woman, it would be brought by the doctor, like Planned Parenthood versus Casey. It was the doctor brought the case. June Medical versus Russo, Holman's Healthy Hellerstedt, right? It's always the doctor bringing it. Although there's some allegations that, why is a doctor standing to bring this? They're just a doctor, it's not the woman. So don't worry about the standing, but this is relevant for our case. So McCorvey became the plaintiff, and she wrote a challenge to the Texas abortion law. I'll give her a sort of end game, or sort of story that came afterwards. McCorvey had a very troubled life. It's not something that we should speak upon lightly. After the case was decided, she became kind of an icon. That's Gloria Allred, who's never aged in all these years. Do you know what Gloria Allred is? Oh my God. Google Gloria Allred. Yes, Allred, Gloria Allred, very famous lawyer. She became a very famous icon for abortion rights, but then in the late 80s, early 90s, she came out as a born-again Christian and became an evangelical opposing abortion. Let me just play this clip. It's short.
In the 1980s, she became an icon for abortion rights groups. However, later in life, McCorvey changed her stance on abortion. She became a born-again Christian. This was Norma McCorvey less than 8 months later, and served as an advocate for the pro-life movement.
This is the day that I have been waiting for.
She regretted her involvement in Roe v. Wade, which she called the biggest mistake of my life.
I'm fighting for life instead of death.
You think Roe v. Wade will be overturned?
Yes. Hope so.
In our next case, Planned Parenthood versus Casey.
So even after I wrote that, her story would change again. Shortly before she died, she came out and said, I was not really a Christian. I was just being paid to say that stuff. And I was an actress. I tell people what I want to say. Apparently she had a relation with another woman. She was living with a woman at the time. It's a tragic life. No matter how you slice it, she was abused by both sides. No matter how whatever you think about the abortion issue, I think she was basically exploited by both sides. I think the abortion people exploited her. I think the religious people exploited her. I think she just was basically being given money by people to just go out and say things. I was Norman McCorvey. I was Jane Roe. And it's sad. You always think about these cases. Roe v. Wade, Doe v. Bolton, right? These are just, Jane Doe. These are aliases. They didn't even use their real name. I know she gave birth to the child. I don't know what happened to the child that she wanted to terminate. I just don't know, but it's alive somewhere. And I don't know where this person is. All right. All right. Any questions on Norma? That's why I never reached out to her. I was like, this woman's had too much stuff in her life. I just didn't want to like. It's sad. I mean, just she didn't want the kid, and these lawyers misled her, because they wanted a plaintiff. All right. All right. You. Yes. I think you're up. Yeah, you. Okay. You want me to do the facts position row?
Yeah. Then she was raped, but she actually wasn't, they were saying.
Okay. Tell me about the law. What was the Texas law at issue? Yeah.
Oh, yeah, like,
At what stage?
I think with any state, or it was like more toward the end.
Michael?
It was before the first trimester.
Oh. Yeah. Yeah, we don't talk about trimester, so we get to row. The Texas law is actually laws in effect right now. Abortion was a crime. There might have been an exception if the mother's life was in jeopardy, but that was about it. In fact, the Texas legislature right now is passing bills to sort of clarify what that even means. It's a curious story. I'll just mention it sort of indirectly. Roe v. Wade declared the Texas law unconstitutional. Dobbs overruled Roe. What happened to the Texas law? Resurrected. Happy Easter, everyone, right? Yeah, he is risen, right? The law comes back. Sorry, is that too much? They're actually called zombie laws, right? Laws that are dead and come back to life. Since you're, I once gave a talk in Ave Maria Law School. It's a Catholic law school in Florida, and there's a Supreme Court case called Bong Hits for Jesus. And I said Bong Hits for Jesus, and I looked at the crucifix come look over my shoulder. Anyway, in 2013, no, I have a Supreme Court fantasy league, Fantasy SCOTUS. I had Fantasy Pope in 2013. I ran a prediction market for Supreme Pope. Yeah. So the problem was, I asked Catholics, who should I put on the short list of a prediction market for the Pope? And they didn't list Francis Bergoglio. They didn't list the one guy that got picked. So I'm like, screw this. I don't know who they're going to pick, right? There was every single cardinal, maybe. I don't know. FantasyPope.com, yeah. I ran this in 2013. Anyway. Pauline is just shaking her head violently at me. Anyway. So the law at issue basically banned abortion at all stages. And there was really no exception for rape, and maybe an exception for the mother's life is in jeopardy. That's what difference between mother's life and health, right? This is, are you going to die? We'll give you an abortion. Oh, maybe you might have some hypertension or preeclampsia or something else. That's not enough. Okay. The opinion begins, and it's this very weird passage about emotion. Did everyone notice this at the very beginning of the opinion? And the court says, we acknowledge our awareness of the sensitive and emotional nature of the abortion controversy, of the vigorous opposing views, even among physicians, and of the deep and seemingly absolute convictions that the subject inspires. One's philosophy, one's experiences, one's exposure to the raw edges of human existence, one's religious training, one's attitudes towards life and family of the values, and the moral standards are all likely to color one's thinking and conclusions about abortion. In addition, population growth, pollution, poverty, and racial overtones tend to complicate, not simplify, the problems. What the hell is he talking about there? Population growth, pollution, poverty, racial overtones? What? Does anyone know what the hell? What is he talking about there? You want to take a guess? Yeah. Well, what's the racial element? What'd you say?
Racial, so, one is the statistics of like which racial groups get abortions, and then two, I think it's referring to a lot of times that history when people were like hysterectomies and abortions were performed without like the woman blowing reservations and then like when they would primarily black.
Yeah. So this is not a pleasant part of the opinion. In the 1970s, there was a famous book called The Limits of Growth. Remember that one? Yeah. There was a fear that the biggest threat to our world was overpopulation. That we would not have enough food to feed everyone. We'd have starvation, we'd have famine. That we'd have overpopulation, we'd have too much pollution. We'd have nowhere to put the garbage, right? People would have nowhere to live. Ironically, they were exactly backwards. The biggest threat was actually underpopulation. I mean, I don't focus on this today, but like the birth rate in the United States is at the lowest point almost ever. We can't sustain our population with this birth rate. It's actually not sustainable. It's not. People live longer and they're healthier, and not enough young people. The society will topple. Look at China, right? They're trying to increase population. They can't. They can't reverse it. Korea, Japan. These countries will implode in our lifetimes. So short of immigration or more birthing, there's not much that can be done there. But many people viewed abortion as the way to fix the overpopulation problem. That if we have just fewer people, that society will be healthier. That's what the court's talking about there with overpopulation, pollution, and poverty. But what about the racial overtones? So I got to quote Justice Ginsburg here. Not a good quote from Ginsburg. She sort of ran away from it later. But she said in 2009, she said, at the time Roe was decided, there was concern about population growth, and particularly growth in populations that we don't want to have too many of. What? She said there was concerns about population growth in groups we don't want to have too many of. What the heck is she talking about? So there were some people who actually viewed that we're having too much population growth in certain minority groups, and abortion can deal with that. Yeah. That's racial overtones. Right? You know, you have Loving versus Virginia only a couple years earlier. And, well, if we have more abortions of certain races, well, they won't have so many of them. It's right there. It's in the opinion. It's funny, when you put something in a Supreme Court opinion, you don't know how it's going to be read in 50 years. Right? We're still reading this half a century later, and it's like, whoa, what's going on there? It's like, I think maybe the Supreme Court decisions today, no one will get in 50 years why they did it. Like, who, like, what do you mean? You didn't let people to turn the plane around? I don't get it, right? Opinions today, wow, Jerry, we're talking about the limits of growth. Talk about the limits of growth. Old friend. Okay. Go ahead. Yeah, we just started Roe. So then he says, but we still decide the case based on the Constitution. Proof of motion of predilection. And then who does Justice Blackmun cite? Which justice does he cite right at the beginning? Holmes. I'm telling you, they can't get away from Lochner. They cannot escape it. They cannot quit it. He says, the Constitution is made for people of differing views. By the way, I mean, just Holmes upheld a mandatory sterilization law in Buck v. Bell. How do you think he reviewed an abortion law? I was like, yeah, that's fine. So again, they cite Holmes, but they're doing Peckham. This is full on Lochner, right? They're pretending, right? We're not doing that. It's almost like, you know, they have to cite Holmes like this, like genuflection, this like this salute to modesty, and then they go do Roe. If you're gonna do it, own it, right? Just say, we're doing this, we're going all in. Don't pretend you're sticking within this Lochner framework. Okay. Everyone with me. Michael, I think you're next. Michael, so we talked in the last cast about the emanations and the penumbras and the Bill of Rights. What exactly is the basis, or which text of the Constitution is the basis of this abortion right recognized in Roe?
The 9th and the 14th Amendment.
Which one is it? Sure?
Fifth.
Andrew? Yeah.
It's 14th.
What about the 9th, though? They mentioned that.
There was reservations to the people,
was more about the 14th than I was about the 9th.
Steven?
But they say whether it's the 9th or the 14th, the restaurant, so it's both.
Doesn't really matter. It's like, whatever. Blackman says whether it's the 9th Amendment or the 14th Amendment, whatever. Yeah. Don't write that in your exam, right? That's not. That would not be a good example in any court today for you to cite. The history of this case is actually fascinating. Justice Blackman, again, no relation, was from Minnesota. He had worked at the Mayo Clinic, which is like this huge hospital there, and he spent the entire summer researching medicine, the Hippocratic Oath, and everything else. He really wanted to understand this issue. And they actually had the case re-argued after two new members joined the court, Justices Powell and Justice Rehnquist. Okay. All right. Brenda, let me ask you a question. What are the state's interests? So why would the state want to regulate abortion? What are the state's interests there? I'm sorry? What are the states asserted? What are you good for? What are the asserted interests in regulating abortion? Why would the state want to regulate abortion? Of whom? Okay. So one interest is protecting what might be called fetal life, right? Another interest, which they don't rely upon, is discouraging illicit sexual conduct. In other words, if you know you can have sex and have an abortion, then maybe you'll have more unprotected sex with random people. So we want to discourage you from doing that by removing the abortion from the table. Texas did not invoke that standard. Instead, they focus on protecting both the health of the mother and also protecting the health of the unborn child. Is there a hand over there? No? Okay. So then the court goes to sort of this textual analysis, which I just want to focus on for a bit. So it's safe to say the framers of the 14th Amendment, when they wrote this, they were not thinking about abortion, right? This was not on their minds. They were thinking about what? Dred Scott, right? Bringing citizenship to the freedmen. At the time this was ratified, almost every state and territory banned abortion, varying degrees. No one spoke of abortion as a right. There wasn't really even the surgery that you would need to provide one. There might have been some different things you could do with things you would drink, but they didn't have surgical abortion the way you might have it in the 70s. But the Constitution begins, all persons born or naturalized in the United States are citizens of the United States. What does Justice Blackmun says? He says, well, it's right there, born. You're not a person until you're born. So therefore, you don't have protection. It's not exactly what it says, though. It says all persons born or naturalized are citizens. So you can be a person before you're born. How do we know this? Remember the rule against perpetuities? Sorry, triggering you. It's long been the law that a person who's unborn can inherit property. For RAP, an unborn person can be measuring life. There's legal personhood. I mean, like I teach as a property every semester, right? An unborn person can inherit property. This is not controversial. So let's just assume for a minute, let's do it both ways, right? Let's assume that an unborn fetus is a life, is a person. We go down to the Equal Protection Clause. The state cannot deny to any person the equal protection of the laws. What does that mean? Protect them equally. So there's actually an argument that's been raised that actually the 14th Amendment requires states to ban abortion. Why? We must protect the born and the unborn alike. That a doctor who terminates a pregnancy is actually engaging in violence, but the police will never prosecute it. In that case, abortion is banned nationwide. Let's say the opposite, right? Let's say that a fetus is not a person, right? Instead, the mother, oh, she said mother, people get mad when I say that. The woman who's pregnant, right? Because not a mother yet, not born. The woman who's pregnant has this liberty interest, in which case abortion must be legalized nationwide. So much then turns on the meaning of person and when fetus becomes a person. At least the Texas law that was in existence in 73 defined a person to begin at conception. The Supreme Court would disagree and have a different standard of when those interests kick in. But the question becomes, who gets to decide these matters? Roe attempted to decide it one set of way with these trimesters. We'll study the Casey decision on Monday, which tried differently with the line of viability. And then we'll wrap up with Dobbs, which said, this is for the democratic process to decide. And I was curious, in the wake of Dobbs, there were a number of state referenda, not in this state, but in other states, which have more or less adopted the viability line. So one of the weird things is, when people vote, they more or less wound up where the courts were. But it was the elected branch doing it, and not the judiciary. Okay. Everyone gets just the textual arguments about what person means. They once saw Josh Craddock here a few weeks ago. He spoke about this issue at some length. Okay, then we get to this right of privacy. And the right of privacy in this case is very different than the right of privacy in Griswold. Why? In Griswold, we're talking about what is a married couple doing in their bedroom? Right? I think everyone agrees that's a pretty intimate setting. What about with an abortion? That is in a surgical medical facility with doctors and nurses and bright lights and stirrups and all these other things, right? Not a very intimate, personal place. I think few people would even say there's a expectation of privacy in a medical office. In fact, it's the opposite. When you're under anesthesia, you have no privacy at all. You know what the hell's going on, right? You are at the mercy of someone else.
I mean, you have the privacy. They're not just letting other people into the room.
It's not a husband-wife decision, right? Okay, you're private from other people, but it's not the same intimacy discussing Griswold. How about that? Fair?
I guess like you're consenting to being seen by those people that are attending.
Okay. Oscar?
Don't you have like a legal right to keep your mouth?
I think that's statutory. That's like a HIPAA thing. I'm not sure that exists in the 70s. But just focus, right? There's a difference between a husband, wife in a bedroom and in a doctor's office. We'll agree on that one at least? Okay, I think we agree on that much. So the court shifts from saying that privacy is about this sort of the space, right, where you are, to privacy is this sort of decision, right? Justice Black calls it decisional versus spatial privacy in Bowers. And that you actually have a decision to terminate the pregnancy or not. But critically, is this the woman's choice? Right? Obviously, I'm pro-choice. Is it the woman, the husband's choice? Right? With Griswold, it's the husband and wife. Here, is it the woman? Or is it the woman in consultation with the physician? If you read Roe carefully, you will search in vain for a woman's right to choose. That's a bumper sticker. That's not actually in the decision. It's about a woman and a doctor making a medical decision together. It's very, a pro-man opinion that the woman can seek their old men doctors on. They can seek the man's advice to decide to have the abortion. This is Justice Blackmun's way of explaining it to the world because, he didn't quite get this. Okay. So the court says there's this right of privacy. It's in the First Amendment, the Fourth and Fifth Amendments. You got the penumbras, don't forget the penumbras, and you got the Ninth Amendment. He cites Meyer and Pierce. Then he cites cases like Loving against Virginia about marriage. Again, this is not about marriage. Nothing to do with marriage. So the Fourth Amendment, Ninth Amendment, 14th Amendment, Ninth Amendment, ultimately it doesn't matter much, but it's probably the 14th Amendment. Okay. So the court now says there's a right of privacy, and the decision to terminate pregnancy falls in that zone. So what do? How do you deal with the Texas law? Well, the Texas law bans it all 9 months. We can't have that. Instead, the court puts together this framework that governed for several decades. This trimester framework. Oh, actually, that's what I want to do. This trimester framework. That's it. Let's do. And you know this, a pregnancy lasts approximately 9 months. You can break it up into 3 trimesters, the first 3 months, months 4 through 6, and then months 7 through 9, right? And the court just, I mean, it makes this up. There's no way around it. They say, well, as you go along the 9 months of the pregnancy, things sort of shift. Earlier in the pregnancy, the child cannot live outside the mother's womb. And then later in the pregnancy, the child can. Of course, neonatal technology changes by the day. It's very different now in the 70s, but as a general matter, as the fetus ages, it can survive better outside the womb. The chance of survival are greater. So the court says is, as you go towards the 3rd trimester, the state's interest in protecting fetal life increases. The state has a very low interest in protecting fetal life at the outset, but then increases as you go along. Also, as the pregnancy goes along, the risk of complications from an abortion tend to increase. So the state has a greater interest in protecting maternal health. That is, they can regulate how the abortions are performed. But at all junctures, they say the mother's decision when it affects her life or health, and health is defined quite broadly, remains. So the court chops up pregnancy into 3 blocks. Justice Rehnquist calls this judicial legislation, and I can't disagree. Right? It reads like a statute. In fact, it's like this press release, like it says, "And to repeat, here are the 3 things." Right? Here are the 3. You ever seen an opinion like that before? Like a press release, like here are the 3 things. Oh, I want to play this Cronkite clip before I forget. Everyone know what Walter Cronkite is? He was a CBS anchor. Yeah. By the way, do you know who Dan Rather is? He went to his law school. Do you know that? Oh, good you know that. Yeah, he didn't graduate, but he went to his law school briefly.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions. The majority in cases from Texas and Georgia said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government. Thus, the anti-abortion laws of 46 states were rendered unconstitutional.
To this,
So again, it basically overnight invalidated laws in basically every single state. Just immediately with this trimester framework. So let's just walk through this. Again, I used to teach this saying that you have to know this framework. I guess I should still say it, but it's not really relevant anymore. But it's sort of like, history, what was the Lochner test? What was the Roe test? This is where it is. So in the first trimester, that is from moment of conception until the 3rd month, the state has very little powers. The state can do nothing to protect fetal life. At most, they can license doctors, but they can always license doctors. Right? In other words, they can't do much more than usual. So really, in the first trimester, the state is basically handicapped. They can't do a thing. In the 2nd trimester, the state gets a little bit more power because there's more fetal life, but not enough. They can regulate abortions, protect maternal health. So there might be some risks that if an abortion is performed, unsafely or something like that, they can regulate that. But that doesn't get you very far, right? The court would say that most of these regulations were actually just pretexts, that they were really just trying to ban abortions by making it harder. It wasn't until the 3rd trimester, which was roughly after the point of viability, that they can restrict abortions to promote human life, prenatal life. But critically, they have to provide exceptions for women's life and health. The health one swallowed the rule because courts would define health quite broadly. It was mental health and other things. So in almost any case, women were able to get the abortion later on. And just about it. I mean, it wasn't hard to find a doctor's note. So under the Roe standard, it was quite capacious, right? So when Walter Cronkite said abortion law in all states were banned, he meant it. Now, there were efforts to get around Roe in the wake of this. I'll talk about that in a few minutes. But the decision itself was actually quite broad, sweeping. Yeah.
you only have to get to the end for it to quote promote human life, but I mean.
Well-
even during the first, like, the quote of human life, I mean, it's still human life, so like, it just seems arbitrary that they like make these.
Well, the non-arbitrary point is actually the viability line, right? Casey will come back to that later. So at least in theory, say, at the point of viability, could this child survive outside the womb? The state's interest changes. So it's not arbitrary in the sense they're making it up altogether. It was arbitrary in the sense that here's what happens this trimester, this trimester. They were making up a legal statute, right? This was legislation. And sort of the irony is in the wake of Dobbs, a lot of states have adopted laws that look a lot like this. In other words, if a legislature had to actually write a statute, they would probably do something like Justice Blackmun did, but of course, they're a legislature, they're not a judge. But yeah, this was what Justice White called raw judicial power, in every sense. You might like the decision, you might agree with the outcome, but the way they got there does not partake in law. John Hart Ely said this isn't law, it's not even trying. In the Gunther textbook, Gunther was a very famous common law professor. He paired Lochner with Roe, as saying they're much the same. Justice Scalia used to say that Roe and Dred Scott are the same because they both use substantive due process to solve a national controversy. Right. So the decision itself, even among people who favor abortion rights, is not very popular. There was actually a book written, What Roe v. Wade Should Have Said. All these very smart law professors said, here's what we were in, right? If we were on the court at the time. Okay. All right. Everyone get the trimester framework. Yes, Sean. Yes, not the fetus. Yeah, the health of the fetus only comes at trimester number 3. So not till month 6, basically, can the state protect fetal life. Questions on the majority in row? Yeah, Oscar.
So well was overturned, actually, unenumerated rights still exist.
Oh, do unenumerated rights still exist? So we'll do a case next week called Washington and Glucksberg. That's in the reading for next week. And Glucksberg said that the only rights, the only unenumerated rights that we protect are those that are deeply rooted in our nation's history and traditions. And the current court likes history and tradition. That's what they love to talk about. So what rights are protected, unenumerated? Rights are deeply rooted in history and tradition. What is one such right? Lochner. Economic rights. The irony is all the stuff in the 1920s and teens, those rights are deeply rooted. In fact, Judge Ho, Eddie's future boss, wrote an opinion saying, well, now that we have Dobbs, what rights are deeply rooted? Economic rights. It was a case called Golden Globe at a tanning salon that was shut down during COVID. He suggested that maybe there's an economic right to have a tanning salon. You have, butchers, bakers, and bronzers, I guess. Sorry, from New Jersey. Yeah, go ahead.
I understand like their fear of Wagner. It's like it seems like they fear that like they're just gonna invalidate like legislature laws.
Yes.
But like ultimately the fear is that they're just gonna protect more liberties or expand liberties past what the legislature wants.
Well, when you say protect liberties, what it really means you're second guessing the legislature, right? That's what protecting liberties means. If the legislature decides we want this morality law, and the court says no, you can't do it because they think it's unreasonable, that's the intervention. That's what Justice Holmes was afraid of. But I want to go back to Sean's question. I don't know that substantive due process has much legs anymore. I think there are no votes in the court to do it at the current moment, not definitely on the right. Then again, I mean, yesterday the court had a case called Mahmoud, which was about, describe it, parents who didn't want their children to be taught books about gay pride. I'll just make it simple, right? And they wanted a parental opt-out. And Justice Barrett was asking, what about Meyer against Nebraska? So Meyer still got legs, apparently. I'll see what happens there. See, I'm giving you like stuff happened yesterday, like this. I couldn't do this lecture on Monday. Things just work. Yeah. They did. You're right. They embraced Harlan's concurrence, sort of.
But then at the very last page of the Dobbs, it's like, it's almost like Lochner where they went all the way to Holmes, but with the Dobbs, they went all the way to Stewart,
What's interesting about Lochner is they basically say we only protect rights that are deeply rooted. So basically, Dobbs brought back the deeply rooted test. And that's how they got rid of Roe, even though Justice Stewart joined the majority in Roe. In other words, they're citing Stewart and Griswold, but Stewart joined the majority in Roe. It's the funny thing about precedent. Once the court has a precedent, you never know it's going to be picked up again. So I thought for years that Glucksberg was dead. I'm like, Randy, why are we keeping Glucksberg in books? If Josh leave it in the book? I'm like, all right, fine. But then when Kennedy left and he did Dobbs, like, oh, we need Glucksberg. I haven't taught Glucksberg in almost a decade. I stopped teaching it. That's like, why would I trying? Now I'm teaching it because I think that's actually the controlling test for substance due process. So this class changed it. I went back to my old notes, man. The last couple weeks of class change a bit every year. It seems. I used to teach June Medical. I used to teach Holman's Health. I used to teach Gonzalez Carhart. You know, all these cases I just don't teach anymore because they kind of they fade away. All right, questions in the majority in Roe. Ironically enough, the vote in Roe is 7-2. And yet all these Republican appointed justices voting. Harry Blackmun, Republican appointee. Warren Berger, Republican appointee. Potter Stewart, Republican appointee. Right? John Marshall Harlan, Republican appointee. You know, these were all Republican appointees voting for abortion rights. The issue of abortion is very different now. When Roe was decided in 73, the evangelical community didn't have this sort of opposition to abortion. Indeed, the evangelical movement rose in response to the Roe decision, right? It sort of galvanized its opposition. In fact, most mainstream Protestant faiths were actually leaning towards liberalizing abortion laws. You know, the Episcopalians and others this is actually Ginsburg's point. She says, Roe maybe went too far too quick. And it was a backlash. Had court not decided Roe when they did, it's entirely possible people would just start repealing abortion laws, the same way they're repealing the birth control laws. But the court intervened in the process, and it created this 50-year backlash that led to the Dobbs decision. So again, Griswold, Frontiero, Roe, the court intervened in contentious issues and in many ways backfired on the democratic process. Overrule Roe became a bumper sticker, it became a slogan when in the past people have debated what abortion laws ought to look like. Yeah.
So because, you know, they kind of saw like the court like infringing on their opinion.
Well, it's sort of hard to sort of summarize in one sentence, but I think the general gist is we want a more moral society, and the court's not letting us do this. And I mean, President Reagan ran on a platform for overruling Roe v. Wade. He said, I will appoint justice to overrule Roe. He didn't. He appointed Senator Day O'Connor, and Kennedy reaffirmed it. But the religious community basically felt sort of betrayed by Roe and was very much opposed. And that's why, I mean, Norma Corby, to her legacy, she was getting paid by all these evangelical groups to basically speak out against abortion. And actually, I think I read this, they knew she had a girlfriend and they just kind of looked the other way. I'm like pretty sure on that last part, but a lot of this is like, you know, woman, she was older, her memory was going, and people tell stories, so I don't even know what to believe. Very, very sad. I feel bad for her though, just altogether. Yes, Bobby?
So you think that, because I guess they have statistics for the trimester and stuff, can it just be rebuttable presumption of constitutionality?
Roe? I don't know. Maybe. I mean, it's not quite. I don't know if it's. I think no. You know what? It's not. I would say Roe's presumption of liberty. It's Lochner. Yeah, not even. The burdens on the government to justify their law. This is presumption of liberty. What else?
So this would be like kind of in the realm of suspect classification, or would it be
It's no. You're thinking of equal protection. This is due process. under the due process clause is a framework. If the right is non-fundamental, like economic right, it's under a rational basis standard. If the right is fundamental, it's given strict scrutiny. We'll do Casey on Monday where they kind of make in between. They call the undue burden standards, is actually like a third tier. But at least Roe, as I read it, and maybe Jerry and Martin disagree, but Roe is pretty much strict scrutiny, fundamental right. They don't quite say it, but I think that's how I always read it for the years. All right. Yeah. Yeah, it's not exactly a right to abortion. It's a right of privacy between the doctor and a patient, the doctor and the patient to make these medical decisions. Yes, Aaron. What do you mean? Are you talking about under the current law or under Roe? Right. Well, there are two things. So the right is not between the assailant, right? It would still be, you would still prosecute the rapist, right? But the idea is, if women didn't choose to have the pregnancy, can she still terminate it? Right? That's sort of the question. So the Roe court would have said, of course she can terminate up to basically the 6 month. So she'd have plenty of time at the outset to do it. Under the current regime, I think the answer that, and by the way, Texas is debating this now, they'd say the mere fact that a woman was raped, that is a problem. We should prosecute this vigorously, but there's another interest at play here that predominates over the mother's interest. And that's the current law. Right, Bobby?
Would we word this, as strict scrutiny, do you think, like?
Again, Roe doesn't use the word strict scrutiny, but that's how I always read it. It's basically strict scrutiny. Casey, probably less than strict scrutiny, but at least Roe is strict scrutiny, I think, at least.
Would you use like narrow tailoring if you?
They don't, Roe doesn't really say that. I mean, the reason why they don't bother with narrow tailoring is to tell you exactly what can be done each 3 months, right? They lay it out very clearly. There's not like a balancing test. It's like, here's what you do in these 3 months and these 3 months. So it's actually very, there's no balancing. They did it for you. But you can imagine the court could have said, abortion is a fundamental right, use strict scrutiny. Texas, go figure out what laws you can have, what laws pass scrutiny. They didn't even like let the states experiment. There's no experimentation. They just said, here, do this. Yeah.
For modern day substantive due process, your fundamental rights is where your enumerated rights are encumbered, but whenever they're deciding what those enumerated rights are, like how exactly are they gonna decide? Like, I guess I would just say, for example, that privacy, like abortion is a private thing. At that point, it's just them making up what they think the law should be, right?
So how do you know if a right's fundamental?
No, it's, they can decide it. They can decide the enumerated rights, but then how do they decide, like, where are these unenumerated?
Well,
rights?
that's my question. How do you know what unenumerated rights are? How do you know if it's, I mean, you can have an unenumerated right. That doesn't matter. It matters if it's fundamental, right? There, do I have a right to wear a hat? Famous example, Scalia would use, like, sure I do. You can't tell me what hat to wear, right? Is that right fundamental? The current test of the court is this deeply rooted in our nation's history and traditions? Roe said, is this implicit in the concept of ordered liberty, which is kind of like modern conception of what do we need as an orderly society? Roe wasn't based in history, couldn't be. The modern test, which what Dobbs says is this right deeply rooted in history and tradition? Is this a right that would have existed in the 1860s? If the answer is no, then it's not a fundamental right, and we afford a rational basis scrutiny. That's what the court would say. Yeah. Well, the Ninth Amendment, again, is one of these sort of cryptic parts of the Constitution. How do you know what these rights retained by the people are? And even if you know what these rights retained by the people are, the Ninth Amendment limits federal power, not state power. And it's not all clear to me how you use the Ninth Amendment to limit state power. So there are a lot of reasons why you would not use the Ninth Amendment. The better question is, why don't you use the 14th Amendment? There's an entire body of scholarship saying that abortion is actually a privilege of citizenship. There's an entire body of scholarship on this, but slaughterhouse, they don't care. Right, so, we're still living in the wake of slaughterhouse, 150 years later. Yeah, one, two.
Me too.
Sure, why not?
Okay. So, wait, go back on the deeply rooted part, because if it's rooted in tradition, then it is a fundamental right.
Correct.
And therefore subject to strict scrutiny.
Correct.
If it's not, then it's a non-fundamental rational basis follow.
You got it.
So, how is that right when abortion, like, didn't come about when, like,
Well, that's why Dobbs overruled Roe, because there was no right to abortion in the 1860s. The idea of a right to abortion didn't exist like the 70s, 1970s, that is. So in other words, what Dobbs says is that a right to abortion cannot be deeply rooted, therefore it's not fundamental, therefore it's given a rational basis scrutiny.
that's Dobbs not?
Correct. Roe was not backward looking. Roe didn't care about history, right? In fact, Roe, I didn't put this in your book. There's this long discussion about quickening. Quickening, what's quickening? And people don't even agree on this part, but at least Blackman said quickening is when the fetus starts stirring, when it starts moving around, when people knew they're pregnant. Like, there you go pee in a stick after a couple of days, and you know that you're pregnant, right? That's what that was said in the decision. So what Blackman said was states would ban abortion after quickening, which was maybe in the first trimester when women kind of knew they were pregnant. It varies. Women know when they're pregnant at different junctions. Like the women who give birth don't even know they're pregnant. It happens. It's crazy. Some woman's like, hey, I know right away. So the problem with that is the quickening was actually used as a criminal marker that you only prosecute a person if they actually knew they were pregnant. It'd be the mens rea element. Did you know the person was pregnant? So the quickening point is tricky. But the short answer is there's no one in the 1860s said there's a right to abortion. Right? Maybe states banned it at this juncture or that juncture, but it was never discussed as a right. So this is not a right that can be deeply rooted. If you read the Kagan Sotomayor, Breyer or Jackson, can't remember, a Breyer dissent in Dobbs, they say, we don't really care about history, and like women couldn't vote then, and why are we looking at this? It's not relevant for our current society. Like they expressly reject the text history tradition, they reject it. And that's the Breyer Kagan Sotomayor joint dissent in Dobbs. We'll get there next week. Oh, Sheldon, I'm sorry, I didn't call on you. Yeah, I wouldn't lead with overruling slaughter. So that's probably not what I'm asking you to do. That would not be a good use of your limited word count. Does that make sense? Argue it under the current law. I mean, unless the question is, should the go to overrule slaughterhouse, then go for it, right? Go free. But that's probably not what I'm asking. But I do want to just stress how much bad law was generated by slaughterhouse. It was such a dreadful decision that generated so much bad law, and we're still coping with it 200 years later. Right? It was a terrible decision. All right. So again, there were only two dissents. Justice White and Justice Rehnquist dissented. And Justice Rehnquist basically says, Lochner, you quote Holmes, but you really didn't peck him. He's right. You gotta just recognize what they're doing. This is legislation. This is not actual law. This is without regard to what the framers have intended in the 14th Amendment. Justice White said this is raw judicial power. The court maybe has this authority, but should not use it. People are now disabled from the political process. You cannot debate abortion. In fact, just to pause, right now the Texas legislature is debating abortion bills. And maybe you like the bill, maybe you don't. But they're debating it. This was impossible 4 years ago. They couldn't do this. Right? Back in the day, if you wanted to decide what abortion was about, you have Justice Kennedy. Right? Well, whatever Justice Kennedy thinks, that's what you can do. So hate it, love it, whatever. There are actually debates being had today that were simply illegal for half a century. I did debate on this last week in UT with one of the lawyers represented one of these women. This is actually tragic. She was pregnant with these fetal abnormalities where basically she had no risk to herself, but the baby was going to be born, basically would die immediately. right? There'll be no life. Like, it could not exist more than a few moments outside the womb. And the various Texas laws that we're discussing focus on where the mother's health is at risk. And she's like, well, I would have no actual health risk. Maybe it might affect my future fertility, but I have no actual risks. And there are these sort of compelling stories, and people actually are discussing this in the elected branches. And someone say, well, rights are not for debate, and that's sort of the contrary point. But it's a very different world that we're even having these sorts of legislative debates. I made a prediction last week in the debate. Maybe I'll be wrong. I think in 10 years, this issue will just fade away. I think within 10 years, people just will be sort of settled on the laws. With the advance of telemedicine, the number of abortions actually increased since Dobbs, not decreased. The number of abortions in Texas remained roughly the same since Dobbs. I think this issue will largely fade away in about a decade, but maybe I'll be wrong. Come back to me wrong later. I don't know. Okay. All right. Anything else on Roe before we move on to Bowers? We almost have time. Anything else on Roe before we do Bowers? Bobby?
One question. You said it was illegal now in 46 states. Is that because of legal ground where they said like this is the law, or like whatever the Supreme Court says? It's like,
Oh, Cooper against Aaron, supremacy?
Yeah.
Yeah.
Is that why that is?
So it's a very good question. The decision in Roe affected Texas law. There was another case called Doe against Bolton, which had a Georgia law. Those are only laws declared unconstitutional, yet nationwide people said, well, we have now to reconform our laws to fit the Supreme Court decision. Roe did not actually strike down laws in 46 states. It couldn't do that. They didn't quite go full Cooper against Aaron and supremacy, but people just always have to follow the Supreme Court's decision. But why do we have Dobbs? Because Mississippi enacted a law that banned abortion. It was 15 weeks. That was clearly in violation of Roe and Casey. And Mississippi said, we don't care because we want to challenge the statute. So I think the story of overruling Roe is also a story of basically challenging supremacy. It's like, okay, Supreme Court, you passed the law. We're going to enact a facial and constitutional law to challenge it. Even Judge Ho was on the panel that that said that the Mississippi law is unconstitutional because he was following the Casey precedent. And the court reversed it. Yeah. Which one, Roe? It basically is. I mean, it was maybe a Freudian slip. I mean, Rehnquist says it partakes of judicial legislation. It reads like a statute. Casey, which we'll do on Monday, tried to fix Roe and make it seem more like a legal decision. It was about liberty and dignity. It's Justice Kennedy's favorite words. How about that on Monday? I know. We'll move quick. So Bowers is a case that actually stopped teaching some years ago. I actually brought it back. Why? Because I think it actually represents how the current court would approach a rights question. You asked me, what would the current court do about rights? Bowers. So the facts of this case are unusual. It's not in the book, but I'll read it to you. This is in 1982. The Atlanta police show up at Michael Hardwick's house, and they were to arrest him because he didn't appear in court. He had charges of public drinking. The roommate let the police in. By the way, this is a Fourth Amendment case also. There's actually a question whether the roommate can consent to a search. You'll do this in Fourth Amendment next year. As the police searched for Hardwick in the house, they noticed the door was partly open. Peering in, they found Hardwick and a companion engaged in a sex act. I'll just leave it there. Hardwick and his partner were arrested on charges of violating the Georgia sodomy statute. So this was a case where the police probably shouldn't have arrested the guy, but they did. The prosecutor chose not to present the matter to the grand jury. So he was never actually convicted of any crime. He was never actually indicted. Instead, he brought up what's effectively a challenge to the false arrest, right? The arrest itself was invalid. And he said that the law violates the Constitution. So the lower court found there was a right of privacy based on the 9th and 14th Amendment, on Griswold, on Roe, and so on. And the case went to the Supreme Court. I don't know why Georgia appealed this case. They should let it go, but they did. So unlike with abortion, there is no fetal life at issue here, right? A ban on sodomy doesn't affect any third parties. It's literally the relation between two people. What intimate relations are they having? And particularly with people of the same sex, reproduction is not in the cards, right? There's not like birth control for a married couple or abortion. There's no reproduction happening with Michael Hardwick and his partner, right? So what then is the state's interest in banning sodomy, homosexual relations? The answer is morality. Morality. What the court describes as moral disapproval. Moral disapproval of homosexual relations. That is the state's interest. Okay. Is that a legitimate basis, right? Well, we have to first ask ourselves, what kind of right is at issue? Is there a fundamental right or a non-fundamental right? The court says the right at issue, the right of homosexual sodomy, is clearly not fundamental. Why? Look at history and tradition. Sodomy was illegal in most states at the time. If you were a gay man, good luck getting employment in the government. You basically were being fired in the 50s and 60s. They were rooting them out. J. Edgar Hoover, who was a cross-dressing gay man, was kicking all the... He had all files on the gay people. It's one of the weird mysteries of the universe, right? How could it be that being a gay man was a fundamental right? So because this right's not fundamental, the court says we apply a rational basis scrutiny. It's a non-fundamental right. And what do you do with a non-fundamental right? We ask, is there some, legitimate interest for the state? The court says yes. What's the legitimate interest? Moral disapproval. The state thinks that homosexuality is immoral, and Justice White says that is enough. Is this a rational way to promote morality? Yeah, passes the very easy test. Therefore, the sodomy statute is valid. But then you have dissents from Justices Blackmun and Stevens. And Blackmun says, you are conceiving of the right all the wrong way. So much turns on how you define the right. Is the right how two men engage in sex? No, that's not the right. The right is intimate association, how two people can love each other, how they connect to each other. And in that case, it's the same sort of right of privacy at issue with a married couple in Griswold. How you define the right dictates the outcome of the case. In Lawrence against Texas, we'll read this one next week. The court says it's not the right of two men to engage in a sexual act. It's about love, about intimacy, about connection with another person. And that is a zone that the government cannot intrude into. When we do Glucksberg, yes, by Glucksberg, there's actually two steps of Glucksberg. We always forget the first step, right? Step two is this right deeply rooted? Step one is how do we define the right? Step one is we define the right narrowly. Because the broader you define the right, if we're talking about, is there a right of privacy? Yeah, you can find that in the laws. Is there a right of intimacy? Yeah, you can find that versus the right of sexual acts between the same two guys. No, that's very narrow. That right's not deeply rooted. The broader you define the right, the deeper the roots will go. And the more narrowly you define the right, the roots become far more shallow. So much turns on how you define the rights. That's step one of Glucksberg. You'll forget step one. Okay. What's curious here, though, is the Georgia statute not limited to homosexuals. What actually is sodomy? It's, oh God, non-recreative sex, put it that way. Non-vaginal sex, that's sodomy. So straight people who engage in non-vaginal sex potentially also were criminals. Curiously, Justice O'Connor would later say, well, the Texas statute only applied to gay people, if I remember correctly. So that violates equal protection. We'll get to that one next week. Okay. All right. I'm running short on time. Okay. one on Justice Berger's concurrence. He says there's no such thing as a fundamental right to commit sodomy. The statute's been in the books for over 200 years. Well, how long was the Texas abortion statute in the book for? About 100 years as well. So for whatever reason, Justice Berger was okay declaring the Texas abortion statute unconstitutional, but he had no favor for the Georgia sodomy statute. There was a story that I think it was Justice Pallett, a law clerk, and he said to his law clerk, you know, I don't think I've ever met a gay person before. The law clerk was actually in the closet. This came out some years ago. I forgot the clerk's name, but you can look it up. And it's often said that the Supreme Court just understood the idea of women getting an abortion. They didn't get the idea of a gay man. That's just something they couldn't relate to, even understand. This would change, though, when Justice Kennedy came on the court. Justice Kennedy was involved in a series of cases involving gay rights. Romer against Evans, Lawrence against Texas, leading up to a U.S. versus Windsor, leading up to a Obergefell, where Justice Kennedy elevated the rights of gay Americans in ways that were perhaps inconceivable in Bowers. So in the same sense that Bowers was overruled by Lawrence against Texas, the court then overruled Casey and Dobbs. So precedents come and go. They go up and down. They're not fixed. So I always ask you to know the laws exist at the time. Stephen? Souter. No, Souter was not yet in the court. Why do you ask? Souter was an interesting guy. By the way, he never got married, lived with his mother till a very ripe age. He would eat for lunch an apple, 4 and all. He ate the entire apple. That was his lunch. He hated DC. I don't blame him on that one. And he was go back to his home in New Hampshire with as much as he could. Interesting guy. I think he ate the stem also. I think the entire apple. I think he ate the entire thing. Yeah. All right. Questions on Bauer. So I did the one super quick. It was mentioned a case called Moore v. City of Cleveland and Palco against Connecticut. I mean, they kind of said it before in a few cases, but this is where they really made it solid that we're looking at the history and tradition. Glucksberg would pick up Bowers. The irony, though, is that Justice Kennedy joined the majority in Glucksberg, but then he voted to overrule Bowers in Lawrence. So that Glucksberg is an important case that I thought was irrelevant, but now becomes relevant all over again. Glucksberg was about assisted suicide, whether there was a right to assisted suicide under the Constitution, whether that right was deeply rooted. All right, where are we? Questions? Or can I wrap up? All right, let's wrap up. So, 14th Amendment, huh? Griswold suggested that we will not do substantive process, but we will do the penumbras in the Bill of Rights. Roe v. Wade said, okay, no more of this penumbra stuff. We will simply say the 14th Amendment protects these fundamental rights, and we will create this trimester framework. But then Bauer seems to say, well, even if there's a right to abortion, there's no right to homosexual sodomy. That's a non-fundamental right. It's not rooted in history and tradition. Review this law with a rational basis. And moral disapproval is a rational basis. Bowers be overruled in a couple different ways. In Lawrence v. Texas, the court overrules Bowers. They say that Texas' sodomy law is unconstitutional, but they do more. In Lawrence and later in a case called Windsor, the court says that moral disapproval is not a rational basis. That animus or hostility to gays and lesbians is not a rational basis and is not a basis for legislation. Okay. Questions? Thank you all. I'll see you on Monday. Okay.